I'll recognize myself to begin with just a couple of questions. And maybe I'll throw it out to Mr. Harbeck, but it sort of goes with the last comment that Ms. Bowen was making as far as educating the investors and the like. So, Mr. Harbeck, you made the comment, which is an interesting one with regard, and I'll bring this all around, with the Stanford case, that in that case that there was actually written notice. Well, your first comment was to the effect that the coverage and insurance, if you will, is protection is for the securities that are held by the broker. And in that particular case, I think you made comments just now saying the fact that actually written notice was made to the investors that they were investing and their money was going, as you put it, offshore, correct?
In the Stanford case, as a part of the investor package that each investor received from the Stanford International Bank in Antigua, the investors, most of whom never gave money to the SIPC member firm at all, but some did. But when they gave their money to the brokerage firm, the money went to the Stanford International Bank in Antigua, and that bank issued a statement saying that the brokerage firm is not liable and that SIPC does not protect the investment. Right.
Okay. That's good to know on that particular case. In all other cases, or the average situation is when the investor goes into the broker's office, there's the SIPC logo there and the implication and whatever that comes with that as well. And I remember when we met for the first time, I guess, the comment was made is that there's a perception that you are covered and insured, if you will, up to $500,000. I remember you saying at that time, no, not in all cases. And I think that's the message that you're delivering today as well from your testimonies. No, you're not covered for $500,000 in all cases. So I guess a very seminal question here is, should we go back to the days of allowing or requiring that people actually have the stock certificate in their hand so that they can be guaranteed that this is actually what they have, if without that you're not really sure what you have?
Congressman, that would solve the problem, but that's just not going to happen. It's not the way the world works. Transactions are done instantaneously at this juncture, and in order to take physical possession of securities, I think is an impractical.
Right. So I would agree with you, but if that's the case that we can't really be sure of what I have in my hand, because as I used to in the old days, then I have to be guaranteed of something or assured of something, and in this case the IRS was, or in certain of these cases the IRS is assured of something because they see the statement, I guess it's a 1099 or what have you, that goes to them saying this is what the dividends or payments out. So they're assured of it. I as an investor, hypothetically, or an investor would say I have the certificate or I have the statement saying this. If you can't rely on, if the investor can't rely on the statement, what should he rely upon then?
One of the problems here, of course, is that the investors in Madoff gave discretion as to what to buy to Mr. Madoff.
Well, in any case, what can if I can't rely on the statement, what should I be able to rely on?
In the overwhelming majority of instances, you can. But what you cannot rely on is that when you give discretion to someone to buy securities and he backdates statement and generates fictitious profits again and again, month after month after month.
Yeah, but the investor wouldn't know about the backdating. I only have a minute left already. As far as discretion, let me just get right to the point on this one. The discretion right now, as far as the situation, when you have a situation like this and the appointing of a trustee, is the selection, the nomination of that process is by SIPC, correct?
Correct.
Would it be a better process to take that step away from SIPC and have it to a so-called neutral party, which would be the SEC, let them make at least the nomination of it, so you would avert any idea whatsoever, real or otherwise, of any conflict that SIPC would have? If not, why would that be bad?
Well, I think SIPC has an extended body of knowledge concerning who has expertise on this, number one, and number two, that knowledge and expertise has to be applied on about an hour's notice. The MF Global case is a perfect example of that.
So if we could set up something within SEC that they would, A, get the knowledge, and B, have a mechanism to be able to make these things quickly, could that address both of the situations?
I'm not sure it could, but there's a further reason. And the further reason is that the people who are saying that these trustees are not comporting with the law are being unsuccessful in that position in courts. It would be different if these trustees were advancing positions in courts and the courts were saying, no, you are incorrect. But in Lehman and in Madoff consistently, the trustee has upheld the law as Congress has written it. And the courts have said that that is the case. So I don't think there is anything broken about the process. Experts are being put in place, and they are doing a good job.
Well, my time has expired, and I'm always mindful of my colleagues. I guess the question not necessarily is whether they are breaking the law, but whether they are whether the intention of Congress is being fulfilled as far as how the trustee is managing the case.
In 1978, Congressman, the Congress investigated that precise point and chose to strengthen SIPC's ability to designate trustees.
Thank you. Gentlelady from California is recognized.
Thank you very much, Mr. Chairman. And let me thank our witnesses who have appeared here today to help us better understand some of the discussions about SIPC and these cases that have been mentioned here today that have played out in the press. I want to understand, can I get a summary of the areas where SIPC and SEC disagree about how to resolve first the Robert Allen Stanford case?
Certainly. The essential dispute is that the SEC's position is a change in the 40-year interpretation of the statute. For the first time, the SEC is saying that SIPC should pay rescission damages to people who are in physical possession of the security that they purchased. That's never been the law, and it is not the law. And the reason that SIPC has not been involved for 2 years is because the SEC staff looked for instances where individuals left assets at the SIPC member brokerage firm and did not receive those assets. There is no such investor. The investors who lost money, knowingly and willingly, sent their money to an offshore bank. And saying that there is some vague connection between, well, it's not a vague connection, to say that you can just sort of smush everything together and say, therefore, the brokerage firm must have had custody of the investor's assets is factually incorrect. The fact is the investors got what they paid for, and they were defrauded. But SIPC does not pay that as a damage claim. These are victims, but they are not covered by the statutory program.
I must say, Mr. Harbeck, you make a very good case. What is the current status of SEC's effort to force SIPC to initiate a claims procedure for Stanford's victims?
The SEC delivered a letter to SIPC on June 15th of last year. Our board examined the issue very, very carefully. The board did not take the staff's recommendation without hiring outside counsel to make sure that the staff recommendation not to start a liquidation proceeding under these circumstances comported with law. We did attempt to resolve the problem. We were unsuccessful in resolving the problem with the SEC, and as a result, the SEC filed suit to compel SIPC to take action. But we have yet to been presented with someone who left custody of their assets with the SIPC member brokerage firm, and that's why we feel we must go forward with the lawsuit.
Thank you very much. Let me just ask about the Madoff case. How can you discuss how clawbacks have been treated by SIPC as it relates to Madoff Stan?
Yes, I'd be happy to.
I'm sorry. Yes.
Ever since Charles Ponzi enacted his own Ponzi scheme, there have been avoidance powers that allow a trustee to reach back to people who have already received assets out of the fraudulent scheme and bring them back into a common pool. That is exactly what the trustee has done, and it's exactly what the task force has looked at with respect to whether that should continue under the Securities Investor Protection Act. And the task force concluded that if any bankruptcy trustee has that authority and right, then a SIPC trustee under the Securities Investor Protection Act should have that right. And the reason is the common pool is expanded, and we don't let the luck of the draw by getting out the day before or withdrawing profits and even your principal just before the collapse of the scheme gives you an advantage over people who are stuck. And so the trustee has used those avoiding powers, and by starting one particular lawsuit, he's brought back billions and billions of dollars into this estate for distribution to the people who need it the most.
Mr. Chairman, are you back?
The gentlelady yields back. Mr. Dole is recognized.
Thank you, Mr. Chairman. Ms. Bowen, even though almost 11,000 indirect investors lost their money in the Madoff fraud, not one single indirect investor was invited to be on the monetization task force. Why is that?
The task force actually was comprised of a broad group of people of expertise, including two lawyers who represent investors, such as the ones you've mentioned. So we felt that their voice was being heard at the table. In addition, we created a website, and we had the Internet forum, if you will, and we had a live presentation where we had an open forum in New York City. I was there at that forum. Investors showed up, and they did speak to the task force. And we heard their words, and we took their comments to heart.
Mr. Harback, do you believe that President Nixon and Senator Muskie and the other supporters that led the 1970 passage of SIPC to provide financial relief for all investors?
That's a statement of extraordinary breadth. The fact is, the statute as originally drafted in 1970 was intended to protect the custody function performed by brokerage firms, and that is we've been following that mission for 40 years.
Do you believe that it's fair and equitable to differentiate between direct and indirect investors?
The indirect investors that you're referring to are people who I was referring to with respect to comments to Chairman Garrett. The trustee did not pay them, but the reason he did not pay them is he will pay the institutions that they own, the feeder funds that they own. So if 5 people own a feeder fund, they will each get whatever portion they get in terms of their ownership.
And will that be considered a single entity? Because I know we're talking about each individual entity has certain abilities to receive resources back. Will that fund that has 5 individuals be counted as one, or will that be counted as 5?
It would be counted as one. And
do you think that's fair and equitable?
Yes, I do, and here's why. There's 2 points on that. First of all, the task force considered that, and considered the fact that small investors in pension funds might well be considered the small investors that are supposed to be protected by this statute. But moreover, the big protection is not the advance from SIPC. The big protection is the share of customer property. And in the Madoff case, this is precisely what Trustee Picard is trying to expand using the avoiding powers. And those funds will, if numbers hold, will receive 50 cents on the dollar, which was an unthinkable result, an unthinkably positive result in 2008.
I just understand what you're talking about, but I think my concern is that the assumption is that these are going to be smaller investors. Could you not see a situation where actually the group were the large investors coming in, and will we not be treated as one?
The size of the individual investor
obviously varies.
is not relevant. What is relevant is whether they had a direct relationship with the brokerage firm. And many of the indirect people had no direct investment.
Well, are you then trying to pick winners and losers in terms of who, as determining the direct or indirect?
Absolutely not.
You don't believe that there's any difference there?
No. If a large investor owns a share of a feeder fund, he will get a proportionate share.
Capped at what, 500,000? Is that correct?
No, sir. The fund itself will get $500,000 plus a share of its pro rata share of the fund, and the pro rata share of the fund is the lion's share of what any investor will receive.
Mr. Harbeck, let me just move on then a little bit. How does the net equity of or the cash in minus cash out computation protect all customers of a failed broker dealer?
This is the methodology that's been used in every single case under the Securities Investor Protection Act dating back to the 70s where fictional statements have been involved. S.J. Salmon in 1973, Adler Coleman in the 90s, many cases in between. These, the money in, money out methodology is not new to Madoff. It is historically what has always been used when brokers enter fictional transactions to benefit customers.
Thank you. I realize my time has expired, Mr. Chairman, but I do hopefully we'll have another round to talk about some clawbacks, which I think is important when we talk about some of these Ponzi schemes. I yield back.
Gentlelady from New York is recognized for 5 minutes.
First, I'd like to thank you for your testimony and voice my support for the task force's recommendation that the 500 be raised with inflation to 1.3 million and to provide pass-through protection to some indirect investors. I think that was a thoughtful recommendation, and I support it. I would like to ask a question on H.R. 757. It is one of the bills that we are debating and is before this committee. And in that bill, the last statement would be used when determining a customer's eligible claim. As was stated, courts have recently ruled that this standard in a Ponzi scheme is not appropriate, and that the standard that SIPC is using, net investment, money in, money out, is more appropriate. And I do see that there could be some problems with this, and I ask you to comment on it. And one example that came into me was investors that most use in this case, that basically the claim could be based on fraudulent information to begin with. So if you're using, the last statement, it could be based on fraudulent information, and it could be a fraud in the first place. And for example, if you've invested $1 million 10 years ago and your statement says you now have a fictitious earnings and that you now have $10 million, you would be treated the same as someone who invested $10 million yesterday. So the former has $9 million in fictitious earnings. The latter had no fictitious earnings. However, both are treated the same. So if the pot of money actually in the Ponzi scheme was $5 million, each would get $2.5 million, and that doesn't seem fair because it doesn't reflect the reality of what is behind that. I ask you to comment on that and other ideas of why you think your recommendation of money in, money out is better, and that of course is what the courts are saying. But I also would like to ask, how do you and Trustee Picard determine when it would be a hardship to claw back funds?
I'd like to speak to your first issue first, if I may, Congresswoman. Exhibit D to my written testimony goes through examples of why the avoidance powers resolve the problems and actually do equity, and that H.R. 757, while well-intentioned, creates actually inequitable results.
Thank you. And we will read that, but now could you answer, how do you and how does Trustee Picard determine when it would be a hardship to claw back funds?
The hardship program is one where anyone who has been sued under the avoiding powers can demonstrate financial hardship, and those are as unique as the number of individuals involved. And I think the trustee, first of all, made a decision not to sue certain of the people who received relatively small amounts, although they're, in absolute terms to me, they're somewhat sizable. But he didn't sue everyone who received more than they put in. But when he did, he was more than willing to listen and apply a rule of reason. That's the only way you can really describe it to a situation. It makes no sense to sue someone when they have no assets or they're extremely elderly.
And my time is almost up. Can you discuss the task force's recommendation to provide pass-through protection to indirect investors in certain ERISA qualified plans, but not investors in other funds?
Oh, sure. In making that determination, we thought, at least with the ERISA plans, that those trustees have a fiduciary obligation. Those are retirement funds. We also thought that, the whole purpose of SIPC is to protect the small retail investor. And given how people invest money today, most people's savings are tied up, frankly, into their retirement accounts. And so we were attempting to address that by really limiting it to that circle of people, frankly, and not to extend it to large institutional investors.
Thank you. My time has expired.
Thank you. The gentlelady yields back. Mr. Hurd is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to thank you all for being here today as we try to understand and deal with these important issues. I had 3 things I wanted to cover, and maybe each of you could address it as appropriate. The first is, can you give us some concrete idea of what the financial solvency of the fund is, especially with the pressures that you face in wanting to raise the maximum reimbursement or the maximum claim amount, and I hope also considering the fact that you want to keep these assessments as low as possible. The second question deals with the assessments themselves. How are you dealing with the fact that a lot of these broker dealers are part of smaller outfits, smaller firms, and how do you account for the pressures that they face as small business people? And then finally, just a general question is: are these reforms things that will require congressional action, or are these things that you all, from your standpoint, would prefer to be able to do from within?
Let me take an attempt to answer that. First of all, in terms of SIPC's financial solvency, prior to the start of the Lehman Brothers case, SIPC had $1.7 billion. Even after paying $800 million to Madoff investors and paying administrative expenses of $300 to $400 million that have brought in $9 billion for the Madoff estate, because we, in effect, turned the spigot back on of assessments, we now have a fund of $1.5 billion. And that is adequate to perform the statutory functions that Congress has assigned to it.
Has anything been drawn down from the Treasury?
No, we have never used Treasury funds. But I hasten to add that if SIPC is to be tasked with some new and radically different level of protection for rescinding bad investments, as in the Stanford case, I would anticipate that the Treasury line of credit may or may not be sufficient, and we would have to assess the industry. To your second point about assessing the smaller independent members, I have met, and other SIPC staff members have met with the National Association of Independent Broker-Dealers to brief them on these issues, and we understand the nature of the problem. They are currently being assessed at 1/4% of their net operating revenues.
Well, and if I could just interrupt, before it was at $150 per member, $150 annually for each member. Is that right?
We assessed on net operating revenues through 1990s, when we reached a target of $1 billion, we cut back to a very nominal sum. But with the onset of the Lehman and Madoff cases, we reestablished a higher target of $2.5 billion that we would like to have on hand.
So what does that mean? Is there a way to characterize that as it relates to the smaller firms?
Yes, if we were to continue.
In a cash number?
Yeah. Oh, in a cash number, it's very difficult because, frankly, the large brokers.
Is it $500, $1,000?
Oh, it varies dramatically, and as Ms. Bowen has said, some of the very smallest brokers have now actually inadvertently had their assessments reduced to zero.
Okay. All right.
But
Go ahead.
in the basic point is that we will be assessing, if we continued at the current rate of 0.25% of net operating revenues, we would reach our target of $2.5 billion between the years 2015 and 2016.
And then the last question, the last question deals with congressional action. Are these things that you all are inviting congressional action, or are these things that you feel like you can handle with in-house?
I think some of the things can be done in-house, but the most changes concerning the limits of protection require congressional action. And when former Chairman Johnson issued the task force, he requested that and raised at the board meetings that we do some empirical studies as to the effect on the industry and on investors before we go to Congress and ask for those changes.
Thank you. My time's about to expire. Ms. Bowen, do you have anything to add to that?
The only other thing I would add with respect to the assessments is that obviously that number is determined based on litigation when and if it happens at time, and so we can't predict necessarily if there's going to be another big failure tomorrow. But so the concept of assessments really depends on, the likelihood of litigation, the outcome. Stanford obviously would definitely be a huge problem.
Yeah. Thank you.
Gentleman yield back.
Gentleman yield back.
Thank you.
Mr. Green is recognized. I think you're next.
Thank you, Mr. Chairman. I thank these witnesses for appearing as well. And I do concur and believe that we should raise the amounts that investors can assume that they may acquire if there is some scheme that's uncovered. Now, let's focus specifically on Mr. Madoff, and I'd like to speak to you, if I may, Mr. Harback. Sir, is it true that Mr. Madoff had, with malice aforethought, statements issued that were misrepresentations?
Absolutely.
And is it true that these statements, and I'm not sure that you've added them, but if you did add them, that they would total probably billions and billions more than you are capable of paying if you paid based upon the statements?
On a money in, money out basis, the customers of the Madoff brokerage firm deposited between $17 and $20 billion. The final statements totaled about $63 billion. He had on hand virtually nothing.
Before going on, let me make it very clear that I really am in sympathy with people who've been defrauded. This is a dastardly deed perpetrated by a criminal mind, without question. The question, however, becomes how do you compensate these victims? And this is why I've said my thoughts are somewhat ambivalent, because I'm trying to do equity. I want to make sure that people can have some confidence in capital markets and confidence in when they go to these brokers that they're going to get some degree of equity. Just address it, please, given the wide chasm between the statements and the money in, money out methodology.
The difficult answer, but the correct answer, which the courts came to, is that to base the payments on the last statement is to allow the fraudulent actor, the dastardly criminal who you correctly characterize, the final say as to who wins and who loses. Further, if you go by the last statement, the unintended consequence of that is you make Ponzi scheme participation a good thing. You make it profitable. So in one of the comments that I made to one of the bills, it was to create a dialogue between a fraudulent salesman and someone who was questioning, well, if this is a fraud, will I get money back? And the answer was, don't worry about that. SIPC will pay for it, even if it goes down, even if it's fraudulent. So it's a difficult question. But the courts that considered it, the trial court, the bankruptcy court, and the Second Circuit Court of Appeals came to the conclusion that, and this is not my words, this is the words of the 4 judges who have considered this, that it would be absurd to let the thief determine who wins and who loses, and consequently you can't use the last statement.
Now, I concur with the chairman with reference to the statement, and to this extent. I want the person receiving the statement, the investor, to have some belief in that statement and to rely on that statement. Is there any means by which we can use technology or somehow cross-reference or give that person receiving the statement the opportunity to, as an aside, are all or most of these persons sophisticated investors?
We make the assumption that they are not.
Okay. Now, they're not sophisticated investors. How can we, perhaps with technology or some other means, give them a greater degree of confidence in that statement? Because the chairman makes a good point. I have my statement. I'm relying on my statement. To a certain extent, there are other entities that rely on the statement. How can we strengthen the statement?
I think you've put your finger on it. I think technology is the answer. In this case, Bernard Madoff, acting as an investment advisor, used his own firm as the custodian of the securities supposedly held for his clients. If you divorce the custody function from the investment advisor function, as is done by most investment advisors, then the problem solves itself. Then the brokerage firm with custody has the securities. It's a check on the system. And I think the SEC has located that as one of the problems in the Madoff case.
Thank you, Mr. Chairman. I yield back.
And I thank you. Gentleman from New Mexico is recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Bowen, as I'm reading through Senator Vitter's testimony, he alleges that SIPC is dragging its feet on solving the cases. Do you have a rebuttal to his testimony?
Obviously, I think you're referring to the Stanford case.
He's talking also the same. He says you're dragging your feet on the Madoff case also.
I would say just given the outcome with the Madoff case that we haven't been dragging our feet and we've been maximizing the return to the investing public. With respect to Stanford, it's a really complicated issue. We decided that we did not have the authority to change the law, to change the statute. And our reading of the statute is such that we felt we had to go to court. I believe that court has decided to be as expeditious as possible in reaching a resolution. And obviously we'll follow the law.
Does the SEC agree with your position or SEC oppose your position?
It opposes our position as to whether or not
they feel like they feel like it is not required to change any law.
I believe, again, I haven't really read their filings, but I believe they think that there may be a customer who is entitled to recovery. We don't see a customer of a broker-dealer.
Do you all get involved at all in the notifications up front that investors are worried about about their investment? Are you all notified at all? You just come in later as the insurers?
Well, first of all, we are not a regulator in any way, shape, or form. And unlike the FDIC, one of the questions earlier was concerning the FDIC. We are not an insurer, and that's not in our name. We do come in, and you are correct, only after the firm has failed.
So are you involved in the MF Global case at all?
Yes, sir. I was notified at 5:20 a.m. on Halloween Day that MF Global's customers were in need of protection, and one of the gentlemen in this room who's on the legal staff of SIPC was in court and had a trustee appointed that afternoon.
Who notified you at 5:20 a.m.?
A member of the trustee, a member of the trading and market staff of the Securities and Exchange Commission.
You remember the name?
Yes, his name was Mike Macchiaroli.
You received the SEC sent an email at 7:29 on October 31st, and that email set forth the basis that they thought that a settlement was going to be reached. Is that correct?
I think you're conflating two cases, sir. A settlement in the MF Global case.
Okay.
Yeah. At 7:29 on October 31st of last year, that was a written confirmation that MF Global had failed and was in need of protection.
Okay.
Subsequent to the 5:20 call from the Securities and Exchange Commission, Mr. Macchiaroli in New York, we put an attorney on a plane that day. And that day, we took over the firm and placed a trustee in position. I think that demonstrates that we don't drag our feet. We had no idea whether we had billions of dollars worth of exposure in that situation, and we did it because that was the right thing to do.
Mm-hmm. You're discussing in another circumstance about the professionals that you all contacted. Who are the professionals that you all contacted? Can you get us a list of that? And what were their positions?
We contacted attorneys from Weil, Gotshal & Manges. We contacted attorneys from several other law firms, the name of which escapes me. Several of them had conflicts of interest. And we felt that, as it turned out, that MF Global was the 8th largest bankruptcy of any kind in history, that would be a poor time to put in someone who had no previous experience in this case.
Let me get one question before my time is out. I'm sorry to interrupt, but you talked about going and getting settlements from, say, people had received a payment, they'd cashed in their account, and you go back and you're not going to let them succeed just because they got paid out the day before the bankruptcy. Do you ever go after the personal assets of the people, the principals involved in these decisions? In other words, Mr. Corzine?
Well, since no lawsuit's been started against Mr. Corzine, I'd rather speak to either past cases or theoretically.
You do go after.
The SIPC trustees are financed by SIPC to take we think it's a good lesson for people who steal money to be held accountable for it, and we will finance litigation to do that and take those people down to their last cent.
All right. Thank you, Mr. Chairman. Appreciate it.
Thank you. Mr. Royce, recognize. Thank you, Mr. Chairman. I guess what's caught our attention, among other things, is the report of the Office of Inspector General, Office of Audits, where they have some very pointed things to say about the oversight. They say, "We found that significant criticism and concern have been expressed about the amount of trustee fees awarded in the two largest liquidations in SIPC's history, Lehman and Madoff." And here's what they say about that. And I'll ask, we'll have a comparison up on the board in terms of the way Lehman in the UK has been handled versus the US up there, but here's the observation from the report.
For the Lehman liquidation, SIPC's trustee fee chart combined both the trustees and the council's time, and the hourly rate ranged from $437 to $527 an hour. Moreover, the fees paid to date for both the Lehman and Madoff liquidations are a mere fraction of the amounts that will be eventually sought. Well, the fees paid to date, I think, are in the order of $600 million. And I guess my question is the same question that the Office of Inspector General is getting to, and that is, do you believe the $600 million plus in legal fees is reasonable?
Yes, sir, I do.
And then let me ask you, if this is reasonable, what would you deem reasonable for a completed Lehman liquidation? Because as they point out again, it's a mere fraction of the amounts that will eventually be sought. Significant work relating to customer claims with pending litigation remains to be done. Now, this is after 3+ years, and of course they point out that they would like additional oversight, that they would like SIPC to negotiate with outside court-appointed trustees more vigorously to obtain a reduction in these fees. So they've got a little different take than on this than you do. What do you think the final cost will be?
The cost estimation for Madoff case in administrative expenses is $1 billion. To date, I believe somewhere in the vicinity of $400 million has been expended of legal fees. Two important things to note. One, not one penny of that came from customers or diminished customer assets. SIPC paid for it all. So SIPC paid for the litigation, which the GAO report, which was issued yesterday or today, indicates brought in billions and billions of dollars in the Madoff case. Customers haven't been diminished in any way, shape, or form by that.
I understand that.
As to the Lehman Brothers case, this is the largest bankruptcy of any kind in history. And what I would refer you to in terms of the person closest to the facts on the legal fees is Bankruptcy Judge Peck in New York. And I've included in my written statement his comments at the Chapter 11 confirmation hearings, where he says the case is coming to an unbelievably successful conclusion and that he congratulates all of the professionals involved. So, my God, the hourly rates these people charge are staggering. Everybody knows that. But in that one instance, and I'm familiar with that, the SIPA trustee did an outstanding job, and I think the fees are reasonable.
But one of the unique situations here is that we can compare and contrast with the situation in the UK. And in terms of return of customer assets, you've got a situation in the UK where of the 21.8 billion of client assets, 20 billion was returned. In terms of settlements with foreign affiliates, in terms of the UK, you have a situation where they have settled with U.S. affiliates, with Lehman Hong Kong, with affiliates around the world. That process hasn't gotten underway here. In terms of general unsecured estate, in the UK, they've resolved the majority of its unsecured claims, whereas in the U.S., they've yet to review unsecured claims. But most importantly is the fees. And you look at the difference, and you look at the time frame, 3+ years, versus what's occurred in the UK. And it truly grabs one's attention in terms of the costs, but also the criticism of the Office of Inspector General brought to the process about the oversight and the way in which we're conducting this, and especially the way in which, you're down to 2 firms doing some pretty major work, or one firm in handling MF Global and Lehman simultaneously, reportedly in the financial press, that is causing some backlog in terms of the ability to push this through.
If
I
I
get
could
your
respond,
response, yes.
if I could respond, actually, the fact that the trustee in the Lehman Brothers case and the MF Global case has leveraged their work incredibly well. The Lehman Brothers trustee just won a case for American investors over Lehman Brothers Inc. Europe before the Supreme Court of the United Kingdom last week. And the exact same issue arises in the MF Global case. This is an example of picking a veteran staff and a veteran trustee who knows what they're doing and does it well.
I'll close with this. Reportedly, part of the problem in terms of making progress is that you've got people pulled off of one case to work on the other case because you've got one firm. But my time's expired.
I can speak to that. I asked that exact same question on the morning of October 31st to make sure that the trustees' staff would not affect either case. I was assured that it would not, and our supervision of the case indicates that it has not.
Thank you. Gentleman from Colorado. And then we'd like to come back to you. Sure. With then, gentlelady from New York then.
Thank you, Chairman. If we can just leave that slide up for a moment, and Mr. Harvack or Ms. Bowen, I am intrigued by the difference in the differences between the two columns. To what do you attribute? Is there a matter of the laws being different in the UK, or how?
It's apples and artichokes. They're just not comparable. The size and scope of the operations aren't comparable. The laws are different. The administration of bankruptcies are different. The fact that they both have the name Lehman Brothers is the reason they're both in the same chart.
Understood. Now, is there something that we can use from the UK? I mean, although two different entities, obviously the Lehman Brothers applies to two different entities, but is there something we can take home from that as legislators in terms of our approach to these kinds of problems?
Well, let's think about Lehman Brothers and MF Global and the Dodd-Frank Act. I think the 8th largest bankruptcy in history was not a Dodd-Frank event, and that's a good thing. So the fact is, I think the system works. It is an expensive system. Bankruptcy is an expensive process in financial institutions, but by and large, the system is working in the United States. Again, the Lehman Brothers holding bankruptcy judge comments on this case really do strike home for those of us who've been living with that situation for several years.
Mm-hmm. In terms of Madoff, I've met a couple of folks who've been directly affected by the Madoff situation. Is there any shred of hope we can offer people who trusted their Madoff accounts?
Well, one thing that the trustee has run across when he has sued financial institutions, saying that those financial institutions knew or should have known of Madoff's problems, he has been running into a defense that he does not stand in the shoes of all of the individual customers. I think he does under the law. Some courts have held to the contrary. If we get some clarity on that, then SIPC could use its funds to prosecute lawsuits against entities that should be held financially responsible, and that would benefit customers at no expense to them. So if the courts do not see it our way, perhaps legislation to give the trustee an overruling of an old case called Kaplan versus Marine Midland would be a tool in the trustee's quiver that he could use to benefit investors.
Okay. Ms. Bowen, any?
Nothing to add to that now.
Thank you. Mr. Chairman, I yield back.
Well, the gentlelady will yield to me. Right. Just a couple quick points. On the point that Mr. Rice was raising, and Nan was raising as far as the two entities, UK and US, if you convert these to dollars, are they the size of the assets of the book of these companies, apples and artichokes? What are the relative sizes?
I think the answer to your question is the overwhelming majority of assets were in the United States. For example, SIPC, the trustee, transferred $92 billion in the first week. And the wind down of the other assets, the non-liquid assets, is being conducted in the Chapter 11 proceeding of Lehman Brothers Holding.
I understand that.
Not the liquidation of the SIPC member firm.
Yeah.
But it's I think the American entity is larger by a factor. I don't know the factor sitting here, no.
All right. And as long as there was time, so part of your position is as well that SIPC has done such a tremendous job. Your point of saying, well, $9 trillion now, I guess, at about a cost of $1 billion in fees in this particular case, ballpark figures. But
that's projected out into the future, sir.
Right.
Yeah.
But I mean, out of that $9 billion, isn't the bulk of that just through one case? I mean, a very great case, the Jeff Pekauer's matter. There was net equity in that case, if my understanding, on Madoff's book, basically saying, hey, you really owe this money back to us, meaning Madoff from Pekauer. So that's what 99% of that net equity in the book was from the Pekauer case, and that was around a little over $7 billion. Is that right?
The overwhelming majority of it was, absolutely.
But
the trustee's not done yet, sir.
Right. So, but when you you have $200 million on top of that, I guess, from the kids of the Pekauer family, which is all good. But I mean, but to come and say, well, we spent $1 billion, which, as you agree, is amazing fees, $500 or so an hour. That's good work if you can get it. I used to be an attorney. I billed at, I guess, a tenth of that or so, or a little more than that. Yeah, so out of the $9 billion when you came here, first I thought that's great, but $7+ billion of that is one case, and so a little over $1 billion comes from all the rest. So I guess you really have to put that in perspective as to exactly what the trustee has accomplished. But for that case, you'd be spending $1 billion to get about $2 billion.
And the answer to your point is, we're not done yet. The trustee hopes. To get back, he hopes to get back 100 cents on the dollar. Will he do that? I don't know.
And I guess, that's good. That's the concern.
But if you say, I think if you said to anyone from any source that you were going to get back $9 billion.
Right. We keep going back to that. Yeah. But we never knew that the Pekauers are out there and the negative equity that they're out there. The one individual had. And this is when you say they're not done yet, and there's the rub, or there's the concern, is that they're not done yet. There's probably not that many more Pekauers, if I'm saying the names correctly, out there anymore. So the rest are going to be the smaller ones. The rest are going to be people that we're concerned about in this panel, and that is, or some of us on this concern in this panel, of going back to those people who, as Mr. Green was saying and shares with me the concern, all they did was rely upon what was sent to them. And to your comment that that makes Ponzi schemes a good thing. Only if there's the intention of, or not knowing that that's a Ponzi scheme. But I'm going over my time. If the gentleman is not ready from Colorado yet, then Mr. Stivers is recognized for 5 minutes.
Thank you, Mr. Chairman. My first question is for, I think it's probably Mr. Harbeck, although probably maybe both of you can answer this one. What would the impact on the SIPC fund be if every indirect investor expected to receive SIPA coverage?
At the start of the case, at the start of the Madoff case, we made an effort to tell every person who thought they even remotely was damaged by the Madoff case to file a claim. Thousands of people did so who didn't even know that they were invested in Madoff. Some of the people who have testified in front of this body bought a feeder fund that bought a feeder fund that bought a feeder fund that bought Madoff and said that they were an indirect investor. So that's like throwing a ping pong ball into a bunch of mousetraps loaded with ping pong balls. I couldn't possibly tell you what the cost would be, because the cost would be capped at the net equity of $17 billion, assuming that they were all owed by feeder funds. But the relationship between broker and customer is really, that's the one part about this that isn't rocket science. Did you open an account? Yes? Okay. If you didn't open an account, you're not going to be a customer.
Ms. Bowen, do you have anything to add to that?
No, not really.
What, do either of you think that SIPC has a responsibility to warn customers about possible signs of fraud or conduct that might indicate fraud?
Whether we have an obligation to do so or not, it's a good thing to do, and Ms. Bowen has recommended and championed on the task force an investor education program. I've been doing what I would call dog and pony shows with members of the North American Securities Administration Association on fraud, and I have in the back of my mind a program that I want to use at Walter Reed Hospital, because you'd be surprised at the fact that people will steal money from amputees. And I've seen enough different kinds of these schemes. I've been doing this for 35 years. And I've seen enough of these things to put together a program where we could say, these are some red flags that you should have. And actually, I enjoy doing that.
Great.
I would add to that, too, that with the task force, we did have some securities regulators who were part of our task force. And we talked about
was that the SEC or FINRA, or who was that?
No, well, Mr. Byrd is here from Alabama.
Oh, some state regulators. Sorry, thank
yes,
you. Great.
State regulators. And so we talked about having forums, maybe throughout the country, to get the word out, and also to, frankly, if there's a way for us to work with the SEC and FINRA to maybe change the language that's in the broker statement, although we know, frankly, that may not solve the problem in terms of education. And then I think finally the task force did recommend that we have a person dedicated to investor education who would work with us to figure out a way to get the word out much more effectively.
Great. Do either of you think that SIPC should be empowered to conduct spot audits to ensure that cash and securities are really in the custody of broker-dealers?
The one-word answer is no, but I'd really like to explain why.
You got a minute and 6 seconds.
There are 5 levels of review of that issue. The internal auditor of the brokerage firm, let's assume he's corrupt. The outside auditor, let's assume that that auditor is either corrupt or incompetent. A state audit, a self-regulatory organization audit, and the SEC. If you added SIPC as a 6th, SIPC would have to hire the experts who are already doing it. And I'm not sure that we...
Can I do a quick follow-up on that? Like in Madoff's case, he was not covered by FINRA, so he wouldn't have had an SRO. He would have only had an SEC, and they actually do it once every 10 years for firms of his size?
I don't believe you're correct, sir. I believe he would... Okay. Every brokerage firm is a member of a self-regulatory organization. It's required.
Okay.
So, yeah, FINRA did not find this, nor did the SEC.
I yield back the balance of my time, Mr. Chairman. Thank you.
The gentleman yields back. The gentleman from Colorado is ready and recognized.
Thanks, Mr. Chair. And thanks to the panel. I guess let's just sort of, and I know you have broken it down into 2 categories. You got the situation where it's a fraud from the outset, or more or less a fraud. It's insolvent as a result of just being a fraud, and then it's insolvent as a result of things falling apart. It wasn't a sham to begin with. So let's deal with the fraud one first. The Madoff, the Stanford, the Peters or Petters, whatever they're called. In Colorado, we had a number of investors who invested in, Company A, that invested in Company B, that then invested in Madoff or Stanford or some other Ponzi artist. As I'm looking at the recommendations of the task force, those you know, everybody calls them indirect investors, are sort of out of luck based on the law today, the SIPC law today, or the task force recommendations, except for those that might be pension plans. Am I right, wrong?
No,
And I'm asking both of you, so.
No, that's correct. That is
Yes,
the recommendation.
Sir, if I could elaborate, though, the indirect investors will share, and I believe in my written comments, I speak to this specifically because I know this is a particular concern to you. If you take a look at Exhibit B to my written comments, it is a letter that I wrote to you and to Congressman Ackerman to make sure that when we settle with one of those feeder funds on a preference or a fraudulent transfer, that the money flows directly through to the indirect holders.
Okay. But I guess I'm just trying from a policy standpoint to understand why the pensioners, and you know, and they're sympathetic, obviously a sympathetic group. I think the firefighters lost some money, or their pension initially was in the Madoff mess. Mm-hmm. So why the pensioners? I mean, I guess I'm happy if they get it, mm-hmm. but I'd like to see others, indirect investors, be entitled to some recovery directly from the fund. What's the policy distinction you all make?
I think one of the things we considered is the fact that with the pension plans that we suggested with the pass-through, there is already a level of fiduciary obligation under ERISA. You know, so we felt that level of protection, if you will, gave us some comfort. If we're talking about people who may invest in a hedge fund, for example, we wouldn't be privy to what the you know, what their arrangement is in terms of, you know, they may have invested in a huge hedge fund in Connecticut.
And I guess what I'm saying, and Mr. Harbeck, I understand your sort of black and white position that you know who's opened an account with Madoff. You can go back, you know, so-and-so, so-and-so, and so-and-so. But the reality of how the system works these days is that you're going to have, or at least in that instance, and I think in many, you've got a number of different investors who invest in Company A, who then conglomerate into Company B, who then Company B invests with the Madoff, with the broker-dealer. So I understand you're wanting to have a black and white line there, but that's not how it works. And the guys who are really getting clobbered are the little investors back here in the indirect investors.
Again, if you focus on the common pool of assets, known statutorily as customer property, that's where the lion's share of any customer's assets is typically restored, not the advances from SIPC. So typically, the person who is an indirect holder will not be clobbered because the entity that has the account will get, typically, not in Madoff, granted, but typically that entity will get a large share of its assets because typically, and here I find myself reluctantly, very reluctantly defending the SEC, they usually find these things at a point where the amount of missing assets is small. And that means that the common pool of assets is in the 95, 98% range. In Madoff, there was an egregious failure that proves that rule. So ordinarily, the entity would receive a substantial portion. There have only been, prior to Madoff, somewhere in the vicinity of 350 customers, entities or any kind, whose claims were not 100% satisfied, individuals, entities, whatever. And the total amount that those claimants did not receive, again, this is prior to Madoff, was somewhere in the vicinity of only $47 million. So I'm not sure that, you know, pounding the Madoff issue is the reality for most people who get caught in one of these unfortunate situations.
Thank you. And Mr. Chair, if I could introduce, if it hasn't been already, the letter dated March 2nd, 2012, from the Agile Funds Investor Committee.
Without objection.
Thank you. I yield.
Gentleman yields back. Dr. Cassidy.
I want to first thank the chairman and the ranking member for allowing me to ask questions. Mr. Harbrecht, I am not a securities attorney. I am a doctor. So your knowledge greatly exceeds mine, and if I say something stupid, it won't be the first time, won't be the last, and please forgive me. That said, let me first ask, was there a settlement offered by SIPC to SEC on behalf of the Stanford victims?
There were settlement discussions, yes, Doctor.
And was one offered?
We made an offer, but I would hasten to add that I won't go into the details on that.
That's fine. That's fine. But the fact that you offered, even though you categorically deny the rationale for in your testimony, gives me a little bit of pause regarding your testimony. Secondly, let me ask you this. It seems as if you have two objections to SIPC expanding coverage. One, that SIPC does not cover losses of an investment, and two, the custody issue. So let me take the first. You quoted a court case earlier in your reply to Mr. Green. Clearly you're an attorney, you defer to court. Do you disagree with the Fifth Circuit Court, which found that a Ponzi scheme is, as of a matter of law, insolvent from the inception? That the value is fictitious, there is no value to lose because the value is not there at its inception. Do you disagree with the Fifth Circuit?
The fact that it is insolvent from the initial moment does not detract from the fact that the instrument received by the Stanford people was a real certificate of deposit issued by a real bank in a real country that is in a real receivership.
It is a piece of paper, all agree with that, but whether or not the value is real or fictitious seems to be the point. And the fact that it's insolvent at inception suggests that the value is fictitious. And I will just make that point, and you can hash that out in court. But
the other thing I'd like to say, Doctor, is this matter is in litigation.
I understand that, but on the other hand, I think
I'm constrained by that.
Your testimony, written and spoken, really went after this case as if it were in case, and I think it's important on behalf of the victims to make the counter-argument, if you will. So if the first point is that indeed the value is fictitious and there may not have been value to lose, let's move to the second regarding custody. Again, knowing that you're an attorney and that you've previously quoted court cases in reply to Mr. Green, you spoke earlier about how you would have to fold in these different entities in the Stanford Financial Group to, if you will, give the Stanford victims standing. And yet there is a U.S. District Court for North Texas that says that the Stanford International Bank and Stanford Financial should be collapsed together. Indeed, that they should be folded. And it is, again, a fiction to pretend that they are different. Now, that effect, my understanding, again, I'm a gastroenterologist, what do I know? Although I feel like I'm kind of in the suite right now. That would not give them standing as a customer?
For a wide variety of legal reasons, the answer is no. Among other things, the independence of the entity in Aruba has been recognized in several other countries, who have not turned over assets to the receiver in Texas.
Now, let me just point out, though, that the Stanford Group Company was a broker-dealer registered with the Commission and a SIPC member, that both that and the Stanford International Bank Limited were wholly owned and directed by Stanford, that the Stanford Financial Group was a brand name under which SGC, SIBL, and others operated to give credibility to SIBL, and that domestic clients purchasing Stanford International Bank Limited CDs dealt substantially, if not exclusively, with Stanford Group Company brokers, and that some SGCs, if you will, account holders, received consolidated statements from SGC regarding their Stanford International Bank loan investment. I could go on, but I think I'm making the point. It does seem as if there is a case for them to be folded together. As the North Texas District Court suggests, this would be the one to do so. Let me just kind of go on for a couple other things because I'm almost out of time. I apologize. I have to admit, you give the hypothetical of, well, we have a salesman that says, go ahead and invest in the Ponzi scheme and you will be covered. And I have to say that there isn't a victim yet who I've learned would have invested in this Ponzi scheme should they have known it was a Ponzi scheme. Now, I will just frankly dispute that. And the idea that somehow, don't worry, you give your $500K to us and we'll cover it on the backside. forget the fact that you've lost the investment value over the period of time it's with them. I'll just make that point. But one last thing, since there was a settlement offer, and since there has been discussion as to the amount of money it would cost for such a settlement, can you give us the cash figure that SIPC thought would be involved in such a settlement?
No, sir, I will not.
Okay,
that is a matter in litigation.
But I will presume because you are fiduciary agents, it would not have been one that would have broken the bank, and I think that point needs to be made. You've been generous with your time. I yield back. Thank you.
I thank the gentleman. All questions have been asked. No, I should strike that. All members have had the opportunity to ask questions, but a couple of members have asked just for follow-up. So what we thought we would do is just split 5 minutes on either side, to split however the members want to on either side. And, oops, I reclaim that whole statement, and we'll start with the gentleman from California for his 5 minutes.
Last and probably in this case least, what is the financial position of SIPC, and how is that affected by how you determine whether the Madoff investor is, when pooled, is eligible for one $500,000 limit or several?
We didn't take SIPC's financial situation into consideration in the slightest in making those determinations. Those determinations are made by the law.
Yeah, I'm asking a financial question. I'm not asking for legal defense. What's your financial position, assuming your position on the Madoff claims is upheld by the courts, as I'm sure you think it will?
Our financial position would be that we've already paid all of the customers who are entitled to protection.
So what's the net worth of SIPC right now?
$1.5 billion.
And that's after paying all of the Madoff claims?
Correct.
And if you were to lose on the arguments that have been raised for Madoff, how far underwater would you be?
Which arguments, sir? There are several.
The argument that each participant in a pool is a separate investor.
I'll preface this by saying we've never lost that issue.
Right.
And I believe the outside is $17 billion, because that would, I assume
that would be the full amount.
Everybody would get paid 100 cents on the dollar.
Okay. Do you have different rates for, in effect, what is insurance based upon whether the securities are being held in one of the generally accepted depository houses, or whether the member of SIPC just says, hey, I got a safe in the back room?
First of all, since it's almost all done electronically now, almost all securities positions are held at a common facility, such as the Depository Trust Corporation or something like that. But we have tried, and many members have proffered the fact that our kind of brokerage firm poses less risk. And every time a group of brokers says that, I can come up with an example of, large brokers.
So you charge the same amount
we
for
charge
everybody?
The same amount for everybody. It doesn't work.
What portion of your members do the we've got our own safe approach rather than using one of the established depository?
I don't think it's possible to go back to the days in 1960s where.
Well, I mean, Madoff did it.
Well, no, I see your point.
Yeah. If Madoff had all the securities,
many brokerage firms, self-custody positions, but in turn, the positions should be reflected at the Depository Trust Company, DTCC. And in Madoff's case, if any examiner had bothered to check between the positions shown on Madoff's records and what was in DTCC, they would have dropped dead on the spot.
If anybody had bothered to notice that he had an audit letter from a one-person CPA firm on a $17 billion balance sheet, that would have been caught too, but I yield back.
The gentleman yields back, and seeing no one else coming in at the last moment, we will then close with 5 minutes, if there is 5 minutes of questions on either side to be split up. I'll begin with gentlelady from New York, and then Mr. Pierce, and then Mr. Stivers.
Thank you, Mr. Chairman. you've brought almost 1,000 clawback suits. How many of those were against institutional investors?
I don't know the answer to your question on percentage. It was done strictly.
Do you ever bring clawbacks against hedge funds or the big guys?
Oh, absolutely. And in fact, if I could speak to your question and simultaneously to a point made by the chairman, many of the clawback suits are in sums that in the hundreds of millions of dollars that have been settled.
The one speculation is that, well, the trustee has said that 75% of the 75% of the property is going to be distributed to institutional investors in the Madoff case. What happens to all the little guys?
That statement was made by, I believe, Mr. Stein in his written statement. The trustee is going to distribute the money pro rata.
I just said, what happens to the little guys?
If there's a claimant who is, regardless of the nature.
So the big guys get protected, and the lawyers get $500 an hour.
No, sir. Everyone gets the same pro rata share.
If you give 75% of the big guys, it looks like the little guys are going to get left out. I suspect I've used my minute there, Mr. Chairman.
No, sir. I'd like to respond.
Well,
if I may.
Let me go.
Every customer.
The chairman owns the time, sir.
Yeah. Let me go to the gentlelady from New York for a bit of time. Do you have any other questions? Then Mr. Stivers is.
Thank you. I have one quick follow-up because when I was talking to Mr. Harbrecht about the Madoff portion, I believe Mr. Madoff had two sides of his business. He had a broker-dealer side and an investment advisor side, and most of the problems were in the investment advisor side, but that's the side that's not regulated by FINRA. You indicated that his entire business was regulated by FINRA, or at least gave that impression, and I just want to make sure everybody in the room and everybody that might see this understands that the investment advisor side was not regulated by FINRA, and that's where most of the losses were. Is that correct?
No, sir, because the custody of the assets would have been at the brokerage firm, and that should have been discovered.
The brokerage firm had the custody of the assets, but it may or may not have had the custody of the assets.
It did not. That's the entire problem.
But that's the point. It may or may not have in the first place.
But FINRA,
there was no requirement that the investment advisor firm keep all of its assets at that broker-dealer firm, was there?
No, but they did.
Okay, that's what
they did.
Well, but there was no requirement, so therefore they could say, well, we've got them somewhere else. And FINRA doesn't. You have to. There's too much coordination required, and FINRA, doesn't have the ability to look at everything. So they're looking at the broker-dealer side of the business, and maybe they missed some stuff. But the whole point is, there's not really an SRO on all of the Madoff business, is there?
No.
Thank you.
Okay.
I yield back my time.
Mr. Green.
Thank you, Mr. Chairman. When the individual investor makes an investment through an institution, and that institution benefits from the common pool of assets, does the institution that benefits from the common pool of assets receive instructions as to how it is to distribute the funds to the individual investor?
That's done by contract between the individual investor and the fund. But in response to Congressman Perlmutter's concerns, when the trustee, has settled with a fund, perhaps on a fraudulent transfer or preference, thus allowing the fund to share in the pool, one of the things that the trustee has done is, as part of the settlement, get an agreement from the fund that the money flows straight through to the individual investors.
Thank you. I yield back, Mr. Chair.
Thank you. And, I think sort of going back to the preference fraudulent transfer piece of all this question is, let's say I put $100 in, I get to fraud, I get $50 back, so I've still lost $50. Somebody else puts $100 in, they get nothing back because they're the last guys in the game. The question is, I'm out 50, but I got 50 more than the other guy who got robbed. So the question is, should we all get robbed equally? And I think that's where this clawback stuff comes in and the policy behind the clawback. As we do these preferences, as say Tremont settles with the trustee, recovers all sorts of money, goes to Tremont. When I'm looking at your letter, and I thank you for your letter of September 11th, actually, or September 30th, how will all these investors from Colorado know that they're going to get treated proportionately as to Tremont's share?
We don't.
In terms of the preferential or fraudulent transfer recoveries.
Well, once the way it works is Tremont would have returned a preference or fraudulent transfer to the trustee, thus enabling them, freeing up, if you will, the entire amount of their valid claim. In the settlement of that preference, the trustee said that he would only enter into this settlement if Tremont or the other entities similarly situated would agree that regardless of any contractual commitments between the individual investors and the fund, that they would pass the money straight through. You've demonstrated one of the hard problems of, what happens when somebody pulls out of the fund itself, not out of the Madoff case. And all of that has to be done at the level where the books and records are for that particular fund.
Okay. Thank you.
Kelly from California.
Thank you very much. Ms. Bowen, I see that you have described to us your work of the task force, and I'm looking at recommendation number 3, protect participants in pension funds on a pass-through basis. And I happen to have communication here from Colorado, from one of your constituents, Mr. And let me just read it to you. My name is Peter J. Leviton. I live in Lakewood, Colorado, at Denver suburban Congressman Ed Perlmutter's 7th District, and I'm a direct investor victim of the Madoff Investment Securities Ponzi scheme and a co-chairman of the Agile Funds Investor Committee of the Agile Group, Agile Group LLC, Boulder, Colorado. In December 2008, Agile had 205 investors and managed 3 primary hedge funds. The group and its funds are currently in liquidation. Now listen to this. A large portion of Agile's funds under management were invested by Agile in the Rye Select Broad Market Prime Fund, the Prime Fund, managed by Tremont Holdings Incorporated, or Tremont Group, and invested by Tremont with Madoff BLMIS. Tremont is a subsidiary of Oppenheimer Funds, itself a subsidiary of Massachusetts Mutual Life Insurance Company. I'm trying to read this so I can get it all in very fast. Is this what you're referring to when you're rejecting the idea of pass-through to all who would claim that they should be considered for protection?
Yes. You mean outside of the pension, we would say other indirects would not be entitled. There would not be any direct customer relationship in that case?
What moves me about this is he goes on to say many of us placed a lifetime of savings in what we believe were safe investments, but were ultimately invested with BLMIS, often without our knowledge. Many of us are now devastated financially and psychologically so. Many of us have sold or trying to sell our homes just to obtain money to live on without becoming wards of the state. Many of us in our 60s, 70s, and 80s and have been retired but have had to or attempting to go back to work, on and on and on. The pension funds that where you have the protection, they're more sophisticated, and of course they should have a lot more knowledge about investments. But these people who appear to have invested in some small entities who were managed by other entities that were managed by other entities had no idea this was going on. So do you feel that they have no right to some kind of protection?
I do empathize with them. They obviously have recourse against, the fraudster in this instance, but SIPC is not
was not really created to reimburse victims such as that, who unfortunately who suffer because they put money in the wrong place. It's really unfortunate, but that's not what we're entitled to do.
All right. Given that, I understand exactly what you're saying, but for those who are members of SIPC, are they advised or told or any regulation or rule about who they represent and how many they represent and who these people are? I mean, what's the responsibility of SIPC to the members who are covered?
I'm not certain I know what you mean, unless you're talking about the Agile to Ride to Tremont situation, something like that.
Yeah, I am talking about this situation.
Well, the fact of the matter is there would be no way for SIPC to know those relationships.
I know, and that's my question. Yeah. In your task force review, did you consider this aspect of it, that you have your members who don't, I mean, SIPC would not know the relationship of the members that are protected to all of these other entities that are involved with them.
Yes.
Was that considered?
It was considered by the task force, and we did hear from investors such as the one that you mentioned. We also, with some of our participants on the task force, particularly the state securities regulator, rightly pointed out, there are Ponzi schemes and frauds that occur throughout their state all the time, and those folks are not entitled to SIPC protection because it's not a broker-dealer. So unfortunately, we do have, really bad people who are taking money from other people, but that's not really what SIPC is supposed to be protecting.
The SIPC has no responsibility in this whatsoever in terms of educating the kinds of forms that you're talking about?
No, that's something we did spend a lot of time talking about, because there is a misperception as to what SIPC is and what SIPC is not. And so one of the recommendations is that we work with the SEC, with FINRA, with the state regulatory agencies to try to broaden the educational pool to, in fact, to hire someone whose job is to work with these entities to better get the word out to the investing public as to what it is that SIPC does protect as well as what it does not protect.
Does the broker-dealer have any responsibility to tell them that?
The only responsibility is to display the symbol. We, at one point many, many years ago, tried to expand the investor education levels by the SEC, and we were not met with very enthusiastic results.
So you need some congressional help.
Well, let's see what we can do on our own first, and then we'll try.
Thank you.
Thank the gentlelady. I thank the panel for your testimony and answering the questions today.